Hi everyone, and thanks for coming to our financial remedies talk. I'm going to take us on a brisk stroll through some but not all of the recent cases which have been decided this year. I'm going to limit them to 2021, and I try to pick those of general interest. And I say a brisk stroll. I mean, if you're watching us live, you'll be aware that it's a beautiful evening. And so I know that you don't want to be in front of a screen longer than necessary. So this is going to take about half an hour, something like that, I think. Depending on how we do, I might slot in a delicious and easy supper recipe at the end, just to ensure that you're still paying attention. Okay, so the first topic, and just let me get the PowerPoint up. The first topic, well, in fact, loose themes emerge from the decided cases this year. And the first of those themes I've called the orders that go wrong, subheading the cases that wake us up at night screaming. And there are three cases that can be shoehorned into this category. And in no particular order, we have Kaczynski and Pardee, Hussain and S&T. The case of Kaczynski and Pardee, it's an interesting case. It was a divorce case where 8 million euros was held in some Swiss bank accounts in the wife's name. This money had come from the husband's uncle and aunt. And prior to the financial remedy hearing, the uncle and aunt issued proceedings in Italy for the return of that money. And the wife instructed her lawyers, Withers, to handle the claim, not just in this jurisdiction, but also in Italy. Anyway, at the final hearing, the parties negotiated, and the court approved, actually, a heads of agreement, a Rose and Rose order, in effect, which included heads of terms in the way that I'm sure we're all familiar with, in which the husband's uncle and aunt, who weren't parties to the case, were to enter into deeds of indemnity not to bring any action against the wife or her advisors. The uncle and aunt did have a lawyer in the wings who was making sort of encouraging noises to the husband's team during negotiations. And the wife was to transfer a big tranche of that 8 million euros to the husband. Well, all fine, but unfortunately, you can probably guess what happens. The uncle and aunt did not enter into the indemnity, and they kept their case going, actually, against the wife, and just weren't really playing ball at all with what the wife had assumed was an accord. And so the draft of the final order was not agreed, and the wife applied under the Thwaite Jurisdiction to vary the Rose heads of agreement. To include an indemnity from the husband regarding the claims by the uncle and aunt, and to withhold the payment of the euros until the husband had given that indemnity. She obviously couldn't get the court to order the relations who weren't parties to enter into the indemnity. Just a quick reminder about the Thwaite jurisdiction. This is the one that relates to the ability of the court to revisit an executory order, one that has yet to be carried into effect. If the circumstances prevailing at the time of the application, it would be inequitable not to do so because of some significant unforeseen change in circumstances since the order was made. The general view was that this would be a jurisdiction that would be used extremely cautiously and conservatively on the decided authorities. Well, the application came before Mr. Recorder Allen QC, and he found that the current refusal of the uncle and aunt to play ball was not a change in circumstances and was, he thought, foreseeable, and that the husband was not the architect of these difficulties, and refused the wife's application. So she had a choice of either to just wear the risk or appeal it, which she did, actually, and she went to appeal the order. It came in front of Mrs. Justice Leven. And she, in this report, provides a helpful summary of the Thwaite jurisdiction and the subsequent authorities, including that of Bazeliansky against Bazelianskaya. She distilled the issue to two questions. Firstly, has there been a change of circumstances? And if so, would it be inequitable not to vary the order as sought? So a nice double negative there. She said, I don't find the words cautious and careful particularly helpful. There are two requirements to the use of the jurisdiction, and their application will ensure that the Thwaite jurisdiction is used with care. There's no additional test, she said, or hurdle set out in the decided authorities. And she also went on to say it's not part of the Thwaite test, that the significant change must be wholly unforeseen. Now, in fact, the judge allowed the appeal. She felt sorry for the wife, clearly. She found that there had been a change in circumstances and that it would be inequitable to leave the wife open to the risk of the contingent liability where the original Rose and Rose agreement was built on the basis that there wouldn't be that risk. So a stay was granted and she was given permission not to transfer the funds to the husband until the indemnity had been signed. So clearly a massive sigh of relief from the wife in that case. The next case is Hussein and Hussein, altogether more prosaic, a more prosaic case illustration. And this basically demonstrates a modest case, but it demonstrates the pitfalls of uncontested hearings where nothing gets properly tested. And at the final hearing, I mean, the husband didn't turn up, didn't file anything or serve for me. The wife blandly asserted that at the hearing in January 2018, with no due diligence by anyone, that the house, which was held by the husband, was worth £250,000 with a £100,000 mortgage on it. And the judge, doubtless taking into account the fact that the husband hadn't bothered to turn up, awarded her £125,000 on the basis of a clean break. And it wasn't until well into 2019, actually, that the husband, showing admirable consistency in his tardiness, got round to trying to appeal it. And it was only allowed because he showed that the mortgage was in fact £200,000. And clearly what must have been an uncomfortable inquiry during the appeal hearing, it turned out that the wife's assertion was based on, I quote, something that she had overheard said a few years before and wasn't based on any document she had seen, which was just a great line, isn't it? I mean, they could have got office copy. There's 100 things they could have probably done, made basic inquiries of the Building Society, but that wasn't done. Of course, the whole thing had to go back to square one. The next case, S&T, this actually is another sort of nightmarish case where there was a huge problem with the original order that had to be sort of dealt with, generating huge cost and delay. The husband and wife were both employed barristers. They'd married in 2007. They had two children aged 14 and 10. And it was one of those cases where they clearly had arguments about absolutely everything, including the children, where the children issues actually turned into care proceedings at one point. So that gives you a flavour. One of the properties, I think it was the former matrimonial home, was a modern flat in a strikingly, what was described as a striking multi-storey tower block in East London. I'm sure we can all imagine it. And that had an equity of about 450,000, and there were some other investment properties. There was what clearly was actually a long, grueling FDR, at which, towards the end of the afternoon, the wife agreed to the husband's offer that she pay him £300,000 in return for the transfer of the flat to her. She wanted the flat, she wanted to buy him out. And there was a Zidious agreement. When I first read this, I thought there was a Zidious agreement because the judge had simply got fed up and sort of gone home, which sometimes happens, doesn't it, late in the day. But in fact, there was a Zidious agreement rather than the Rose and Rose approved heads, because there'd been no decree nisi. Now, what the wife intended to do was borrow money against the flat on a mortgage and pay the husband out. However, fate intervened. Of course it did, because we're reading about it in a court report. And the mortgage valuer gave a nil valuation due to recent government guidelines following the Grenfell Tower disaster, because there was a potential issue with the cladding. Now, the wife thought this would just be a paperwork problem, and she surprisingly pushed ahead with engrossing the Zidis agreement into an order, and went so far as to get the court to approve it. I mean, the order was made. What she didn't do was because by this stage she was aware, obviously, because she'd already made inquiries of the mortgage company and got the valuation. She was aware there was a potential problem. But I mean, in hindsight, I'm sure she'd have gone back to the other side and said, look, there's a potential problem. Hang on, that we might be dealing with a significant change of circumstances, but she didn't. And of course, as things turned out, there was a big problem with the cladding, and massive remedial work needed doing, significant delay, and she couldn't borrow the money to pay off the husband. And it ended back in court. And because it was that sort of relationship, that there was no, I mean, they each occupied the opposite end of the spectrum. The wife sought to get rid of the whole order, set the whole thing aside and start from scratch. The husband was seeking to enforce, his attitude was, I've got the order, I don't care about the cladding, sale, I get the proceeds up to what you owe me. It came before His Honour Judge Hess, who, of course, is a significant figure in our new Universal Financial Remedies Court. He's actually second in command of that court's hierarchical structure, which structure you can actually find online now, in a chart which has been labelled as a judicial organogram, which, I don't know, shades of Woody Allen. Anyway, Judge Hess found that the wife was plainly aware of the difficulties prior to the order being approved, and that she'd taken a gamble, essentially. And it wasn't a Barter event for obvious reasons, because the relevant facts didn't emerge after the order, but before. And as for a mistake, the risk was known. It was a sort of Donald Rumsfeld known unknown, where at the time of the order, a risk was known and assumed, but eventuated to an extent that W wasn't expecting or hoping it would. And that failed the test, said the judge, of unforeseeability. He held that the correct date for determining whether the set-aside circumstances were met was the date the order was approved, rather than the date of the Zidius agreement. It wasn't an executory order, by the way, so just harking back to the Thwaite jurisdiction, that wouldn't have been available. However, in seeking to do justice to both sides, and it's a great judgment, actually, I mean, it's a very fair judgment, realising that the sale of the flat in the current uncertainty would result in significant loss, the judge allowed Section 24A and Section 24A4 of the MCA to come galloping to the rescue. And this is the power that the court has to delay sale of the property. And interestingly, there was no default sale in the order, but that the court still had the ability, of course, to order sale on the husband's application, but also to delay sale, to choose the time of the sale. And so he ordered that the sale should be delayed by 3 years to enable the wife to remedy the cladding issue and either get the mortgage she needed or get better value if it's sold. The husband got full interest on that, by the way. So it came at a cost. But again, one senses the judge described it as a score draw. But I have to say, I suspect the wife was more relieved than the husband about all of that. Right. Next case, we're leaving cases that keep us awake at night, sort of subheading, and we're moving on now to MPS. Now we're all familiar with this jurisdiction, of course, quite a common application in the beginning of proceedings. The case of Rattan and Kuwait is an interesting case, not least because it's a modest asset case, and how many of those get reported? And this is particularly rare because it was actually a double appeal, which I'll explain in a minute. The parties were in their 40s, 2 children, the youngest was 9. The husband was an IT consultant during the marriage, operating through a company, and the wife was a teacher. So, I mean, this wasn't a big money case. The total outgoings, said the wife in her Form E, were about 5K a month, 5,000 a month, of which a sum of just under 3,000 represented the shortfall from her expenses to her income as a teacher. And she included in her outgoings a sum of £650 for school fees for one of the children, £650 a month. She alleged, and the husband didn't really refute the fact that he had just sent a significant six-figure sum over to his brother in India, which the husband claimed was in respect of debts he owed to his brother. Anyway, it came before a deputy district judge. In fact, the hearing lasted a whole day. The report doesn't really tell us what went on, but it was clearly quite a rough and ready determination of the wife's application, and the judge ordered the sum of £2,850 a month. The money being sent abroad by the husband perhaps made the judge a bit salty about his claim that he had no income. The wife based her claims on her Form E outgoings. She claimed school fees, as we've heard, with no separate application, which the judge took into account. The judge also directed that steps be taken to reduce the mortgage, and apparently there was a deal that the parents could, the parties could have taken advantage of that would reduce the mortgage by a lot. Anyway, the husband appealed, and the circuit judge, so the first appeal, the circuit judge, surprisingly, allowed the appeal, but didn't substitute any alternative figure. He simply said, well, the wife's made out a claim to MPS, but I'm not going to say what it should be. So, I mean, anyway, she, unsurprisingly, appealed that decision. The circuit judge, who allowed the husband's appeal, took the view that there were three errors. There was no proper critical analysis to the wife's needs, and that the judge shouldn't have included school fees. He also thought the mortgage point was an error, but I won't trouble you with that for the moment. The wife successfully appealed to the Court of Appeal, and in the leading judgment, Lord Justice Moylan summarises the MPS jurisdiction. It's quite a useful report for that reason alone. He emphasised the need for reasonableness and fairness. Not every case needs a specific MPS budget. He felt in this sort of case, the Form E was fine, which of course is, I mean, that sounds sensible, doesn't it? It's not beyond the wit of people who are representing, an applicant in an MPS application just to fill it the bits in the Form E outgoings to tailor the MPS application rather than going to have to go to the sort of extra effort of producing further pleadings on it. That was the view of Lord Justice Moylan in this case, anyway. Whilst the court, he said, should look at immediate needs, this did not mean only monthly outgoings, as opposed to, for example, annual costs. This was actually argued by the husband. There was even an exchange about the TV license. I think there was an argument that because that's an annual cost, then that's not an immediate cost for MPS. I mean, the Court of Appeal was having none of that, obviously. And importantly, Lord Justice Moylan made clear that there was no need for a separate application for a school fees order. You can just ask for it as long as it's set out what the cost is. You don't need to separately apply for that for an order under MPS. The court had jurisdiction to include that in its determination. So that deals with that. So next case is Finch and Baker, which spreads a number of topics: pensions, income needs, and conduct. It's another double appeal case, interestingly. And what strikes me about the decision, I mean, it's not something that's been concentrated on by the commentators, but what strikes me about this case is the obvious lack of information in the pension experts report. And the fact that nobody really did anything, at least effectively, about it. But we'll come to that in a sec. The wife was 55 and the husband was 67. The main asset was a BBC pension with a CE of just over 2 million. A pensions expert report produced that didn't contain a proper analysis of the tax implications or the lifetime allowance implications, either generally or in the event of the fund being shared on a given basis, as you'd expect in a report, I think anyway. That report was dated March 18. These dates are important. that report itself was based on information from 2017, and the final hearing wasn't until January 2019. So even at first instance, that report was pretty out of date. Anyway, the district judge, the wife made it clear she wasn't applying for any updated valuation expert evidence about it. The district judge decided to award quite a generous share to the husband of 48.6% of the BBC pension. The wife appealed. On the appeal, the circuit judge reduced the husband's share to 34%. And during this appeal, the wife's counsel said, while he was happy for the court to proceed on the existing report, which of course by this stage was very out of date, it was nonetheless wrong for the court to rely on it because the pension had increased significantly in value since the date of separation, which seems a tricky argument. But anyway, when the judgment was handed down, the wife's team and the wife herself, unusually, I think both sent requests for clarification to the judge who dealt with the first instance appeal. Including, and one of those was a request for an updated pensions report to check that the percentage that the court had determined was indeed the correct percentage to cater for the husband's needs. Well, the circuit judge wasn't having any of that and just said, no, you're trying to reopen the arguments, and stuck with his determination. So the wife appealed again, which came in front of the Court of Appeal, and they dismissed the appeal, finding that the court had done its best on the available evidence and that the wife had had multiple chances to apply to obtain and deduce updating expert evidence about the pension, simply arguing that the time had elapsed and so the figures were outdated was insufficient. There's always some uncertainty about pension value, of course, built into the statutory timetable for implementation of a pension sharing order. It's not possible for there to be mathematical precision, said Lord Justice Moylan. The date of the report and the values and the date of the decision aren't the dates that the pension provider is going to be implementing the pension split. It's another example, said the Court of Appeal, of the court's powers under the MCA being exercised in a broad and discretionary way. And then an appeal won't be allowed simply on the basis that the effect of the pension sharing order may be different from that envisaged by the court on different figures at a different time. In response to a criticism of the judge's lack of analysis of the income needs, which was another head of appeal, Lord Justice Moylan said that the judge was well able to assess a party's income needs without them being subjected to detailed cross-examination. He's well able to assess what is fair without, frankly, banal cross-examination. We've all experienced that. We've all maybe engaged in it. I'm making no admissions. Anyway, for good measure, the Court of Appeal put to the sword the wife's argument that rather than the husband indulging in bad conduct, which is always a difficult task, as we know, he'd made what the wife described as a negative contribution to the marriage, which the court said was an unhelpful oxymoron. That was simply trying to get a conduct argument in under a different guise. The wife also tried to argue that, the wife's counsel at the appeal tried to argue that the court had jurisdiction to set out in pounds, shillings and pence what the pension income should be and leave it up to the pension provider to work out what the percentage was post-order at the date of sharing. And again, the Court of Appeal scotched that argument, saying there's no jurisdiction to do that. Okay, moving on, AZ and F. Sorry, missed that one out. I'm going to mention in passing a couple of cases. The first is AZ and FM. Not a case of universal application, but and of course it's quite rare that we're dealing with cases where there's a periodical payments order in favour of a child. In this case, a deputy district judge, I think at the Central Family Court, in response to an application by a husband to reduce periodical payments for the benefit of a child, decided to capitalise the award. the husband appealed. He argued there's no jurisdiction to do that under the MCA. And it was heard by Mr. Justice Mostyn on appeal, and he upheld the decision. He found that there was indeed jurisdiction to capitalise child PPs pursuant to Section 31(5) of the Matrimonial Causes Act. I have to say, it takes a careful reading of that section, that subsection, to see how he got there. But got there he did. He did stress that this power would only be exercised in very rare cases. A rare bird was his expression. In the overwhelming majority of cases, he said, the risks and uncertainties inherent in capitalisation will lead the court to continue PPs. And one can think of the obvious reason, for example, that you're never going to get a clean break on capitalisation of a child PP's order, because the child can always come back for more, and there would be, a lingering sense of unfairness about that. But it's going to be a very rarely exercised jurisdiction. The case of WX and HX is a case. It's just a good case illustration. It doesn't say anything. It doesn't create new law or anything, or bend any established principles. But it's just a helpful. My reading of it is it's a helpful, case illustration of the treatment of matrimonial non-matrimonial property. And Mrs. Justice Roberts gives a very helpful summary of the principles and the case law on this important issue. She decided that the wife had quite a lot of money in the trust, which was clearly a non-matrimonial asset, but it was managed by the husband, who I think had some expertise in that department during the marriage. His activities did. I don't think that they did. The impression one gets is that they didn't really produce much increase in the value of the assets in the trust, and the judge found that in managing it, that money did not become matrimonialized. Great word. By his management of them. So but anyway, have a look at that case too. There's a case which isn't in my the PowerPoint, called Atapur and Rezai Namagi, which is actually a 2020 case, late 2020. The reference is England and Wales High Court 3729. It's, I suppose, a cautionary tale that the parties engaged in complicated and lengthy financial remedy proceedings, which cost six-figure, £100,000 in excess of, I think, in legal costs. And the whole thing had to be undone because the parties had wrongly assumed or wrongly understood that decree nisi had been pronounced. And in fact, it hadn't. And it makes for sad reading, really, that they got the tapes of the hearing where everyone thought that the district judge had dealt with the issue, and she clearly hadn't. So, it's an obvious point, but it's sometimes the simplest things pass us by, don't they? But that's quite a good that is quite a good cautionary tale, I suppose. A bit like the Hussein case, where just a bit of extra effort would have produced the proper mortgage, figure rather than just making assumptions. Okay, well, we've had our half an hour, and I'm just going to quickly tell you a really, really delicious dish, which was a game changer during lockdown. And you're going to thank me for this, because it is absolutely delicious and really straightforward. Chicken thighs, skin on, brown them, chuck them in a pot with a jar of pesto. If you want to be adventurous, chili pesto, can of chopped tomatoes, cook it up till it's done, chuck in some olives and creme fraiche and some coriander, and I promise, a bit of salt and pepper. I promise you, it's just really subtle flavors, and it's delicious. There's no mucking about with onions or other, complicated ingredients. It's all of this is in your cupboard. Bit of fresh coriander on the top, rice, enjoy. Now, thanks for coming along, and we have an exciting programme ahead of us this summer, so keep a lookout for more talks that we're going to be providing at 42 Bedford Row, and enjoy the rest of the evening. Bye-bye.